Welcome to the Deep Dive. We're here to unpack complex topics and really get you up to speed. Today, we're tackling something huge: artificial intelligence. It's changing everything so fast,
It really is.
especially generative AI. The systems creating new text, images, videos. It seems like magic sometimes.
Hmm.
It's exciting, definitely revolutionary, maybe a bit unsettling. Because it's not just cool tech, it brings up big questions, particularly around rules and regulations.
Absolutely. Huge questions.
So our mission in this deep dive, we're focusing on the legal and policy side, specifically where AI meets open data in the EU.
A critical intersection.
We're drawing from a really solid, brand new report, July 2024,
Yeah.
from the European Commission's data.europa.eu initiative.
Very timely.
Our goal,
Yeah.
to give you the shortcut. Cut through the noise, understand what's important, and what it actually means for you. Let's get into it.
Let's do it.
Okay, so AI. It's not a niche thing anymore, right? Its impact on business, government, the global economy. It's vast.
Undeniable.
The report we're using highlights potential for, and I quote, radical, unprecedented changes. How we live, how we work.
And that power, that transformative potential, it hinges on AI's ability to learn from, well, just enormous amounts of data, large volumes of data, as the report puts it.
Right, and that's where open data comes in.
Exactly. There's this inherent, really close connection. AI systems, AIs, they thrive, they really flourish when they can train on lots and lots of data.
Okay,
For AI to work well, you need what people often call the 3 Vs: data volume, just sheer quantity; data variety, diverse sources, which helps make the AI more capable, less biased; and data veracity, the data needs to be reliable, accurate.
because garbage in, garbage out, basically.
Precisely. Bad data means bad performance. And open data ecosystems, they often have that breadth, that reliability. They can become the essential source material that high-performance AIs need.
So it works both ways. Open data feeds the AI.
Provides that repository of usable training data.
And AI, in return, can analyze those huge data sets, find insights we'd never spot otherwise. Kind of supercharges the data ecosystem.
That's the potential, absolutely. A really powerful synergy.
But there's always a but, isn't there?
There usually is with powerful tech. AI brings new challenges, legal ones, policy ones.
Okay, like what?
Well, you see issues on the input side. That's how AIs are built and trained. Think intellectual property, data protection. Big concerns there.
Right.
And then there's the output side, how these things get used, their impact, and crucially, who's liable when they mess up.
Liability. Yeah, that's huge.
And that's where things like the EU's proposed AI Act come into play. It's trying to tackle some of this.
Okay, let's pause on that because this next bit, it really hits home. AI can gather just so much personal data.
Unbelievable amounts.
And the report talks about significant and sometimes catastrophic impacts on our rights, on society, privacy, data protection. These are right at the forefront.
They have to be. Europe has a strong fundamental rights tradition, especially around privacy. It's deep-rooted.
Like the Charter of Fundamental Rights, the convention.
Well, exactly. Article 7 and 8 in the Charter, Article 8 in the ECHR. Historical precedence showing privacy is fundamental. And the big framework for data protection now is, of course, GDPR.
The General Data Protection Regulation.
Okay.
So how does GDPR, with its really strict rules and rights for individuals, how does that square with how AI actually works? Because AI can be pretty opaque, right?
That's the core tension. It's a fundamental clash in several key areas if we look at the GDPR principles.
Okay, break it down for us.
All right. First, lawfulness, fairness, and transparency. This is tough because of the black box phenomenon.
The black box, meaning you can't easily see how the AI reached its decision.
Exactly. It makes accountability incredibly difficult. How can someone give informed consent or challenge a decision if they don't understand the why?
Good point. Okay, what else?
Then there's purpose limitation. GDPR says you need to define upfront why you're collecting data, but AI development data often gets repurposed.
So you train it for one thing, but then it reveals potential for something else entirely.
Precisely. Which clashes with that upfront definition, and you could argue it might even stifle innovation if you're too rigid.
Okay, next.
Data minimization. Collect only what's necessary. But AI, well, it loves data, lots of it. The more the better, often.
So the temptation is always there to grab more than you strictly need.
A strong temptation, yes, collecting excessive amounts.
Makes sense. What about accuracy?
Accuracy. This is complex. Datasets are diverse, always changing, leading to potential errors, biases, and inconsistencies. Plus, AI output isn't always factual truth. It's often a statistical prediction.
Like the cancer example, 99.5% chance.
Exactly. That's not a definitive yes or no. So how do you apply the right to correct inaccurate data when the output is probabilistic? It challenges our idea of accuracy.
Yeah, that's tricky. And data storage.
Storage limitation. Keep data only as long as needed. But AI needs those vast training sets. So there are concerns about keeping personal data beyond what is strictly necessary. Erasure gets complicated too.
How so?
There's this idea of an algorithmic shadow. Even if you delete the raw data, its influence might linger in the model's patterns. True erasure is hard.
So deleting the data isn't enough.
Not necessarily for the model's learned behavior. Retraining models to fully remove that influence, that costs a lot computational and engineering expenses. There was that big Google Spain case.
Right, the right to be forgotten.
The court ruled for erasing derived data in search results. It set a precedent.
Okay, last one.
Integrity and confidentiality, sensitive data, interconnected systems, they're vulnerable. And AI faces specific threats like adversarial attacks.
Data poisoning, what's that?
It's where someone deliberately feeds the AI bad or manipulated data during training to corrupt its results or make it behave weirdly later on. Sneaky stuff.
Wow. Okay, so those are the principles. What about my rights as an individual under GDPR, like Article 22?
Ah, yes. The right not to be subject to decisions made solely through automated processes, crucial right. But again, in the opaque AI world, exercising rights like access, correction, objection, it's challenging when the how and why of a decision are hidden in that black box.
It feels like you're fighting a shadow sometimes.
It can. That's why accountability mechanisms are vital. We have data protection impact assessments, DPIAs, under GDPR now.
And the AI Act is bringing in something new.
Yes, for high-risk AI systems, it mandates fundamental rights impact assessments, FRIAs, looking at broader societal impacts, not just data protection. More transparency, more oversight.
Okay, let's ground this. Healthcare is a huge area for AI. The report calls it a pioneer and a significant beneficiary.
Definitely. Lots of promising EU projects. Encore Relief for cancer aftercare. Rebecca using wearables for breast cancer survivors.
OncoScreen for colorectal screening. LECIA looking at lung cancer risks using open and clinical data. Amazing potential.
Truly groundbreaking stuff.
But the risks. Health data is incredibly sensitive, getting explicit consent under Article 9 of GDPR. That's paramount.
Absolutely critical.
And then there's function creep. Data collected for health reasons may be being used for something else entirely.
Yeah, like we purportedly saw with COVID tracing data in Singapore and Germany being used for criminal probes. That erodes trust fast.
And cybersecurity.
Yeah.
Just terrifying in healthcare. That Dusseldorf hospital attack, a patient died.
A tragic example. And the Elekta ransomware attack hit cancer treatments nationwide. Even personal devices like insulin pumps aren't immune.
It really drives home the need for super robust data protection, transparency.
And collaboration. Everyone involved needs to work together to manage these risks effectively.
Okay, let's shift gears. From data privacy to creativity. Generative AI writing poems, making images. It really blurs the lines between human and machine-generated content. How does copyright law even handle that?
That's the million-dollar question right now. Let's look at the input side first, the training data.
What these models learn from.
These big foundation models, language models, image models, they're trained on just masses of stuff from the internet. Text, images, much of it potentially protected by copyright.
So articles, photos, art.
Exactly. Now, copyright is designed to encourage original works. It gives authors exclusive rights, reproduction, communication, and moral rights, like being credited. The key word is originality. It needs the expression of the intellectual creation of the author, their personal touch.
Okay.
So when AI does text and data mining, TDM, it's essentially copying large quantities of material. That copying, it typically falls under the reproduction right, meaning...
Meaning the copyright holder should ideally authorize it.
In principle, yes. They have to authorize the use of their works.
Which explains a strong dissatisfaction from creators. Artists suing AI companies because they feel their work is being used without permission.
Precisely. It's a major flashpoint. The EU tried to address this in the 2019 Digital Single Market Directive with 2 new TDM exceptions.
Exceptions, okay.
Article 4 is a general one for commercial TDM. It allows mining lawfully accessible works. But, and this is a big but, there's an opt-out mechanism.
Meaning rights holders can say, no, you can't use my stuff for training.
Yes, using machine-readable signals or contracts. It's a significant weakening of the exception from the AI developer perspective. Then there's Article 3, specifically for scientific research TDM by research bodies and cultural institutions. That one's mandatory, no opt-out.
But they can still protect their networks.
Right, security measures are allowed. But this difference, especially the opt-out in Article 4, it raises a big question.
Does it put EU AI developers at a disadvantage compared to somewhere like the US with its fair use doctrine, which is generally more flexible?
That's the debate. Does the opt-out hinder EU competitiveness in AI development? It's a concern.
Okay, so that's the input. Now, the output side.
Yeah.
An AI paints a picture. Can the AI be the creator?
Yeah.
Who owns it?
Under current EU law, no. The approach is very human-centric. AI systems currently cannot be authors of copyright-protected works.
So purely AI-generated stuff, it's not copyrighted.
Generally, no. Works produced solely by AI fall into the public domain, free for anyone to use.
But what if a human used AI as a tool? AI-assisted output.
Ah, that's different. If there are sufficient traces of human creativity, the human made significant creative choices in the conception, execution, and redaction phases, then yes, it can be protected by copyright.
But how much human input is sufficient?
That's the gray area. What degree of human creative intervention is required is hard to determine, really fuzzy right now.
And ownership of that AI-assisted work, still a human.
It's far less clear. Could be the user, the programmer, the trainer, the investor, maybe co-ownership. Often it's just solved through contractual agreements for now.
Okay. And can AI output infringe someone else's copyright? Like if it generates something that looks suspiciously like an existing artwork.
Oh, definitely. If it copies a substantial part of a protected work, that's infringement. Mimicking a general style, usually okay. Reproducing original elements, not okay.
But who's liable if the AI infringes? You can't sue the algorithm.
Exactly. AI has an absence of legal personality, so who pays? Is it like a faulty product under product liability? Do we need a specific AI liability regime? Lots of debate, no clear answers yet.
So looking ahead, generative AI and copyright, what's the future look like? Seems messy.
It is messy. Giving copyright to AI output itself feels weird. AI doesn't need the same incentives as humans. And think of the side effects.
Like what?
A potential flood of AI-generated creations, maybe overwhelming markets, or making it harder for humans to create original works that stand out. Some suggest maybe related rights or sui generis rights, special unique rights for AI output, mainly to protect the investment made. But that could still squeeze human creators.
Any talk of compensating humans?
Yes, there are calls to compensate human authors, maybe through something like an AI levy system, because AI is essentially building on the foundation of human creativity, but much faster and cheaper.
Wow. Okay, so data protection, copyright. It's a minefield. This brings us back to the EU AI Act. The AIA, Europe's big plan to sort this out.
It's the major legislative attempt, yes. Aiming for trustworthy AI that helps society but also protects health, safety, and fundamental rights.
And its main feature is this risk-based approach.
Correct. Really distinct and important.
Right.
Risk is defined as the combination of the probability of an occurrence of harm and the severity of that harm.
Makes sense. So what are the levels?
4 main categories. Top level, unacceptable risk. These are just banned outright. Think AI for social scoring by governments or untargeted scraping of facial images. Just too dangerous.
Okay, banned. What's next?
High risk. This is where most of the regulation focuses. Requires strong risk assessment, management, and mitigation measures.
Examples.
Things listed in Annex 5 of the Act. AI and critical infrastructure, education, employment, law enforcement, justice administration. Areas where failure could have serious consequences.
Right, got it.
Limited risk. These systems aren't banned or heavily regulated like high-risk ones, but they need transparency requirements. You need to know you're interacting with AI.
Like chatbots or deepfakes.
Exactly. Users need to be aware. And finally, minimal no risk. This covers loads of common AI applications, maybe an AI video quality enhancer and AI spam filter. These aren't regulated by the AIA itself.
Okay, 4 tiers. But
Yeah.
you mentioned something about big models like GPT-4.
Ah, yes. General Purpose AI models, or GPAIMs. The Act has specific rules for these, regardless of those risk categories.
Why?
Because they're so powerful and versatile, their impact is potentially huge across many areas. So their providers have extra obligations. Things like creating technical documentation, having a policy to respect EU copyright law.
Connecting back to copyright.
Yes, and providing a public summary of the content used for the training. More transparency there, too.
So who actually has to follow these rules?
Yeah.
Who are the operators?
Good question. The main ones are providers. They develop the AI and put it on the market. They face the most obligations. Then you have deployers. That's anyone using an AIS under their authority, typically an organization using an AI tool professionally.
Right.
But here's a key thing. A deployer, or even someone else like an importer or distributor, can become classified as a provider of a high-risk system. If they make a substantial modification to an existing high-risk AI, or if they change its intended purpose so it becomes high-risk, then they take on the provider's obligations.
So you need to be careful how you tweak or use these
You
systems.
have to be very careful. And the Act's reach, its territorial scope, is broad. It applies even if the provider or deployer is outside the EU, as long as the AI's output is used in the EU.
Global reach. Okay. For those high-risk AI providers, what are the absolute core things they must do?
Well, top of the list is establishing a solid risk management system. It's not a one-off check, but a continuous iterative process. Identify, analyze, evaluate, mitigate risks, repeat.
Ongoing process. What else?
Proper data management and data governance, especially for the data used to train, validate, and test the AI. This includes actively looking for biases.
Bias detection. That's mandated.
Yes, an examination aiming to identify possible biases and taking appropriate measures to identify and prevent them. And importantly, the AIA actually creates a specific legal basis to process sensitive data, like health data.
If it's strictly necessary for bias detection and correction.
Exactly. It acknowledges you sometimes need sensitive data to fix bias related to those sensitive categories.
Interesting. Any other key duties?
Oh, yes. Detailed technical documentation, automatic logging or record keeping, transparency so deployers understand the system, ensuring human oversight is possible, and meeting high standards for accuracy, robustness, and cybersecurity.
It's a comprehensive list. Really sounds like they're trying to build in safety and accountability.
That's the goal.
But what if companies don't comply? What are the teeth in this act?
Significant teeth. There's a whole detailed system of post-market monitoring and enforcement measures. And the fines, they're serious.
How serious?
For breaking the rules on prohibited AI, up to EUR 35,000 or 7% of their total worldwide annual turnover, whichever is higher.
Wow, 7% of global turnover. That's huge.
It is. There are lower tiers for other violations and reduced amounts for SMEs, but the message is clear. Compliance is not optional. Plus, there's a broad right to lodge a complaint for individuals or groups who believe the act has been infringed.
Okay, so bringing this all together, what does this mean in practice for, say, an organization listening right now? If you're working with open data and AI, what should you be doing?
Well, even if your project seems like minimal risk or isn't directly covered by the AIA, the report suggests the Act's requirements offer valuable input. Good practice, essentially.
It's a first step.
Understand your project and your role. Are you acting as a provider or a deployer? Is your specific use case maybe exempt, like purely scientific research? Get clarity on that first.
Makes sense.
Data management. Even if not strictly required, adopting the AIA's principles is smart. Make design choices explicit. Define your data collection processes and origin, assess the availability, quantity, and suitability of data you need, and crucially, always be examining possible biases that could negatively affect people.
Proactive bias checking. Good advice.
And risk assessment. The report rightly says introducing AI always entails a measure of risk that must be managed. So do some form of risk assessment for any AI project.
Even simple ones.
It's prudent. You can look at guidance from standards bodies like ISO or NIST alongside the mandatory DPIAs or FRIAs where they apply.
Yeah.
Manage the risks.
Right. And this isn't all happening tomorrow, is it, the timeline?
No, the timeline of the Artificial Intelligence Act is phased. Prohibitions kick in 6 months after entry into force. GPAM rules after 12 months. Most high-risk obligations after 24 months. Some specific areas even later.
So there's time to adapt, but also things will likely evolve.
Definitely. We should expect guidance and clarifications from the Commission and the new AI office as implementation rolls out.
So connecting this all back, the big picture.
The legal framework is absolutely still very much in flux. We see the huge potential open data fuels AI. AI adds value to open data. That synergy is real.
But the challenges?
Also very real. Uncertainty about operating AI within current data protection, within IP law. and the risk that the benefits end up unbalanced in favor of the AI providers,
Right.
the AIA. It may prove to become a part of the answer, but its real-world effectiveness, its impact on EU competitiveness, those are still open questions. We'll have to see.
So the main takeaway, the recommendation.
It really comes down to awareness and reflection. For open data providers, be mindful of the opportunities and risks. For policymakers, actively reflect on the implementation of AI strategies. Think carefully about which data sets should be available for training and under what rules. It requires ongoing thought.
A lot to think about. We've covered a huge amount today, this complex dance between tech innovation, our fundamental rights, intellectual property.
It's incredibly intertwined.
We hope this deep dive has helped illuminate where things stand with AI regulation in the EU and where they might be heading.
And it really underscores that we need new and more effective ways to strike a balance between innovation and privacy protection, finding that sweet spot where AI helps society without undermining our rights.
So here's a final thought for you to take away. AI is evolving incredibly fast. What changes do you think are most urgently needed, not just in laws, but in how we understand and talk about AI as a society to really harness its power responsibly? What does a truly AI-aware society look like, and what part do you play in building it?